It's fantastic to be here amongst so many collaborators, long-time allies, colleagues, agitators. Uh, when I think about the journey that we've had together over the last 10 or more years in relation to this particular subject matter, it's particularly heartening to see a full room this afternoon after such a fantastic day of discussing this very specialised area of responding to young people's use of violence in the home. Before I go any further, obviously, I want to acknowledge that we're doing this and we're meeting here for these discussions on stolen Wurundjeri lands, and I want to acknowledge that wherever we are, for people joining online or listening later on, that these always were and always will be Aboriginal lands, and to kind of recognise, particularly in the context of the justice reforms that we're seeing at the moment in Victoria and winding back of bail laws, that this is going to have a particular impact on young people. Young Aboriginal people, and particularly thinking about the convergence of those with the topic that we're talking about today. So the topic that we're talking about today is really the kind of essentially, does one size really fit all? The challenges of applying Victoria's standard legal response to young people's use of violence in the home. And it's, as much as we talk about adolescent violence in the home or young people's use of violence at home as obviously a national issue, it's a very Victoria-specific issue in relation to the standard legal response which is required. So in many, many years ago, I was part of working in government which looked to expand the definition of family violence under Victoria's Family Violence Protection Act to recognise the wide range of forms and types of behaviours that could constitute family violence, and really recognising the diversity of experiences for victim survivors at that point. And we thought we were pretty groundbreaking. We were pushing the envelope. It was the broadest definition in any kind of comparative legislation around Australia. And for example, there are some jurisdictions in which the definition of family or domestic violence is still pretty limited to intimate partner violence used by somebody over a particular age. So by comparison, in Victoria, we have a very, very expansive kind of framework. What we also have, and then this has been particularly kind of escalated or heightened since the Royal Commission into Family Violence, is a very proactive policing response. So what that has done is kind of converged to mean that over the last 10 to 15 years since that definition of family violence was expanded in the 2008 legislation, it means that there's a certain consistent proportion of respondents to police family violence call-outs and family violence intervention orders, which are young people. So those young people are made visible because of the way in which the system identifies their behaviour and responds to their behaviour with a particular kind of framing. Now, noting the fantastic VLA presentation earlier in the day, it's really important to understand that this particular framing, the response that we have as our predominant response to family violence in Victoria, is first or initially a civil response. So it's, unless it involves behaviour that can classify as criminal or warranting criminal charges, we impose an intervention order which is not supposed to be about past behaviour or punishing or responding to past behaviour. It's supposed to be about recognising risk, recognising the fear of the victim survivor that this risk might occur again, this behaviour might occur again, and putting a stop to, arguably, through an order on that behaviour from happening again. So, on paper, that sounds like pretty sensible. And it might be reasonable to assume that a civil response is better than a criminal justice response in that context, but it still has major impacts that we'll explore in this discussion. It also might be reasonable to assume that a protection order, the imposition of a protection order, is always a good thing, that getting an order in place, which is kind of the language that you often hear around the courts, equates to safety. But this is definitely not always the case, as the discussion today will explore. So I've come to this work after particularly, and just kind of fell upon this realisation of what our standard legal response is doing in the course of research, ANRO's funded research called the PIPA project, which looked at the legal and policy response to young people's use of violence in 3 different jurisdictions around Australia, looking at the sort of the significance and the meaning of the different legislative and policing contexts that either make an issue really, really visible or mean that behaviours by young people become less visible to the system. And what we found particularly through that research, which involved not just focus groups, obviously, with practitioners, but also case file reviews of court and legal aid and CLC data, was that we are stuck with this very, very strange situation in Victoria where, while we recognise that a child as young as 11 does not have the capacity to commit a criminal offence, and where we question their capacity to understand that an offence was criminal up to 14, we're prepared to impose a family violence intervention order on someone as young as 11 who might have a significant autism diagnosis or for other reasons related to trauma, be completely incapable of understanding, let alone following an intervention order that the court might impose. That's because the Family Violence Protection Act, unlike the Personal Safety Protection Act that was referred to by the VLA crew in their fantastic presentation this morning, does not require a court to consider whether the respondent, the person against whom the order is imposed, has the capacity to understand or comply with the order, and nor, as it happens, does it require a court to consider the safety issues where a young person might be removed from the home and placed with another adult. So there's just a major blind spot in this legislation, and that's the kind of blind spot that we want to unpack during the course of the discussion today. We're incredibly lucky to have this amazing crew here today, who can share their experiences, their extensive experience and perspectives from different angles in responding to this this particular challenge in terms of the standard legal response to young people's use of violence in the home in Victoria. So we have Grace Buckley, who is very, very experienced Victoria Police member who's worked has a specialisation in responding to young people in that area and actually advises and monitors and follows up referrals in that regard. We have Aly Butchers, who works at Youthlaw, has very extensive experience in CLC practice and appearing in the Children's Court, advocating for young people. And we have Negar Panahi from Victorian Aboriginal Legal Services, who of course, in bringing her experience as a practitioner in VALS, as specialised young people's practice, Nalu, will bring her observations about what the legal response is doing for young people from Aboriginal communities. So our first question now, noting that Grace is here to talk about her experience on the ground and what her team tries to do at a local level rather than any kind of representing any operational positions from Victoria Police. Can you just outline some of the factors and constraints that Victoria Police officers need to consider when identifying a young person as potentially using violence in the home? What sort of things are your team able to do in this situation?
There's a lot going on, but I think at my local level, so for everybody, I'm a youth specialist officer. I work in a proactive policing team, specifically at Wyndham, Hobsons Bay and Maribyrnong, so inner west suburbs of Melbourne. I've worked there for quite a long time, and I've seen a variety of how things are rolled out in Melbourne, in the inner west. And we look at police response, I suppose we're looking at here, and constraints that frontline members have in their response. So I'm not a frontline member, I'm the next one that reads the family violence risk assessments and the narratives afterwards. But when I think about the members that go to these 000 jobs where a family member has picked up the phone and has said, we need some help, my young person in my home is harming somebody within our family, I first think, the members that go there have this risk assessment they've got to do, which was spoken about earlier, that it's just for adults. So there's not actually questions for young people. And so you've got police officers attending that went to a police academy, had 30 odd weeks of police training to cover, all aspects of the law, and they're expected to be a social worker, a disability specialist, health worker. And so that's my main constraint that I see, is that they have to assess what's going on in this family just based on that.
So much room for discretion?
I wouldn't say so. I think when I read the reports once they come to our office, I can see the members when they've gone above and beyond. They're the ones that go, oh, police have been here before. I'm going to read that report on the way to that house to see what happened last time. I'm going to see if there's any other services involved. Oh, maybe there was already a child protection notification, or, oh, there's already an NJS involved. So they might explore that with the family when they arrive to see who is helping this family. But then you've got members that just go, oh, this is really complex. They're a teenager. I don't know what to do here. And that's where I think we go to that situation where they go, there's harm involved. I'll go back to baseline, which is the family violence is ticking these boxes. I need to get the intervention order.
Fantastic. Thanks, Grace. And Aly, can you describe what happens in terms of the process when a family violence intervention order application is brought against a child? How is that experienced by a young person?
Yeah, so in the context of family violence intervention orders, it's nearly always police who are bringing the application. So something's gone on at home, and a parent or a sibling or another family member in the home or a neighbour has generally called police, though it's certainly not uncommon for the young person to tell us that they themselves called police, seeking help. Things obviously turned when the police came. So police come, Grace, correct me if I'm wrong in any of this, they usually separate the family members out, speak to them, and then they have to decide who they think is the primary aggressor in that scenario. If an intervention order is being made, or the police are asking for an intervention order to be made against a young person, that means in that situation, police have identified that the young person is the primary aggressor. They'll put in an application to the court. For anyone who knows what a family violence safety notice is, you can't have those against young people who are 18. So usually police are getting quite quick court dates. That first hearing is done in what we call ex parte. So it means only one party present. So that's police or the applicant. And so generally the first time the young person's hearing of it is when police come to their house to give them a copy of the paperwork, or they're getting a phone call to come down to the police station to be given a copy of the paperwork. So it's already sort of escalated, I guess, legally by the time the young person and often their family are really aware that it was going to go sort of that far. So then young people come to court, hopefully on the next occasion, though it is, we heard earlier in the day from VLA, a really common problem where police are saying that they don't need to go to court. If they don't go to court, an order can get made against them. That's really problematic because they're sort of, no offense, Grace, actively, sort of denying that young person the opportunity to get legal advice. I mean, some parents are proactive, or services that might be involved with the young person are proactive and, might know that ourselves or VALS or another legal service exists, and they can reach out ahead of time to get some advice, find out if that's correct. Do they need to go to court? But that certainly doesn't always happen. And so there are a lot of young people who do not come to court, do not get the opportunity to have legal advice, and are getting orders made against them with little to no understanding of what that means, the risk it's putting them at of future criminalisation. So that's a really big problem as well. If they do come to court, they get given legal advice, and there can be, sometimes we can sort it out in the first hearing, sometimes there's 2 or 3, and it's very rare in children's court intervention order matters that they go all the way to like a final hearing where the evidence is tested and the court's making a decision. I personally have never seen one. I don't know about Negs. They're usually pretty discouraging of them going ahead. And usually there's been enough time for things to settle down and for us to introduce other things that are more appropriate than the legal response. But throughout that time, they're locked in, they've got court dates, they've got things hanging over their heads. The intervention order may be being inappropriately sort of weaponized at home by parents as a form of parenting, or, weaponization of the intervention order by a perpetrator in the home. So it's really problematic in between those court dates, just to have these orders sitting there, seemingly benign, they're civil, these are things you shouldn't be doing anyway. But yeah, it's more than that. Very recently, so the start of this year in metropolitan Melbourne, all intervention order and criminal matters have been moved into just the children's court, the specialist children's court, which in theory is a great idea, but it was just done with not a lot of notice to everyone. So that's got a bit of teething issues. The benefit of that, though, is that we do have more specialised magistrates overseeing these matters. They sit only in the children's court. They've got a better understanding of some of the nuances, the things these young people are facing and whatnot. That's not the case for regional courts. And what was happening recently as well in broader metropolitan Melbourne is that magistrates that are sitting in the magistrates court, they're exactly the same magistrate who's doing children's court matters. So there's no change in their approach. They have, through no fault of their own, well, the judiciary should be, I think, having greater training no matter which court you sit in, but they don't know, they don't understand. And so they're using an adult lens when they're looking at these child situations, and they're very limited in what they can do differently, what they even know to do differently.
So next question is for you. What are the implications for a young person if an FEIO, particularly a final order, is put in place? What are the potential impacts of a breach of these orders, particularly in the face of the pending changes to bail laws that we're looking at this particular week in Victoria? How are these compounded for Aboriginal young people?
Look, family violence and intervention orders are complex, and I think the idea that an order, which is a piece of paper at the end of the day, when you walk away, it's a piece of paper, the idea that this order can somehow fix the underlying reasons behind how we've ended up in court is a very simplistic way of looking at it. And I don't think at this stage it's the appropriate tool to assist young people to address those underlying issues. So really, I mean, the matter comes before the court because there are safety concerns. An incident occurs, there are safety concerns. It's the immediate sort of knee-jerk response. But without having a specialist response to young people and the issues and the behavioural issues that they present, and that could be a range of issues. That might be AOD, alcohol or drugs. That might be that it's a mental health concern. Without actually addressing those underlying issues, the implications are, as Aly sort of touched on, is that what starts off as a civil order will end up in the criminal jurisdiction of the Children's Court. And I think something that I take great issue with, and VALS takes great issue with as well, is that despite this being a civil order, and for people who haven't sat in Children's Court before, an intervention order, an application, or if it's an interim in place, yes, it's a civil order, but where are the kids sitting? We have young people who are sitting next to other young people who are not pro-social peers. We have young people who are 12 and 13 years old sitting next to other young people who have committed or alleged to have committed quite serious offences. And what you're doing by this approach of going forward with introducing the young person into the court space and introducing the young person into the children's court, generally speaking, is you're giving them a taste of what's next, essentially. And when you've got 12 and 13-year-olds who don't understand that the consequences of this civil order is criminal offences, you are setting up this young person to fail by giving them this piece of paper and expecting them to understand really the depth of what it means or what it's meant to serve. And I think that's another issue in treating. It's a very blanket way of dealing with family violence, in that you're treating children as young as 10, 11, 12, like you would with adults. You're expecting that a magistrate who's sitting up all the way up there, can't even see them, the young person's so little, you're expecting them that they've communicated, you understand that if you don't follow these orders and you don't break things and you don't yell at mum, that they're going to appreciate what the consequences are following that. And even still, I think we haven't actually spoken about what are the drivers, what is it that has led this young person to coming into contact with Victoria Police. I think it's also important that we really consider whether Victoria Police is the appropriate channel or the appropriate organisation to be the first on scene when it's the first time this family has ever come to the attention of Victoria Police, whether there should be, well, in our view, there certainly should be Aboriginal family violence specialists who are the first on scene to be able to see if, you know, this can be de-escalated, whether we can stop the process as it is in its tracks before we get into the criminal legal system. I think in our practice, we've seen young people, and just for context, so I'm the principal managing lawyer of Bulletin, which is the youth specialist team at VALS, and our primary area of practice is criminal law. However, what we see time and time again is young people who have intervention orders where it's an application is always attached, a criminal charge attached to that. And often what we see is, and we'll get into this a little bit later, around young people who have been charged with criminal offences and intervention orders where they are the respondent, often are victims of family violence. And I think that is very easily forgotten, particularly when we're looking at an isolated incident. It's very unfortunate that it's not until the young person is linked in with us where we dig a little bit deeper and really see, well, you know, this is just one incident where the young person has had enough. I can share an example that I think it's important for people to know is that we had a young person who was 15 years old at the time, was living in out-of-home care, and had come to our attention because he was a respondent in a family violence intervention order. From that, there were charges, multiple incidents. But when you would read these summaries, something felt off. Something just didn't read right compared to the kid that I'm seeing in front of me and what police are saying the behaviours have been, and that this kid is the problem, this kid is the one who's using violence in the home. And it wasn't until 4 or 5 months later where that young person finally felt like they were in a safe environment to open up about what had happened to them, that we found out that this young person had been abused at the hands of their carer for years prior to that first incident that led to the intervention order. And I think those are real examples of what happens. This is just one case that I'm speaking of, but there are many incidents where young people are criminalised later into after what seems like, you know, we regard as a civil order. The reality is for young people, if you don't address those drivers, we are very much walking that path to criminal charges and the criminal justice system.
Grace, we heard a fantastic presentation earlier in the day by Victoria Legal Aid, which highlighted a dramatic increase in the use of personal safety intervention orders against young people. And for the audience, you'll remember that legislation does enable consideration of the capacity of the respondent to comply or understand with it. But what are the challenges there? Can you describe the trends that you're seeing in this regard? What does your team's approach look like when those issues arise?
Yeah, I saw those stats this morning and I thought, that sounds about right for the health and safety RVO. So I'll tell you what I'm seeing. When parents have a young person who is being severely bullied, assaulted, targeted by another student, they first go to the school and go, what are you going to do to help my child? The school goes, oh, it's kind of happening off school grounds. If we know something's going on, help you. Or they'll say, you know, we've, that kid's got some time now, or young person who's been suspended or whatever. But it's not preventing what's going on. And we spoke earlier as well that mediation should be offered, right? And that's a conversation. And help with schools. Do you have somebody qualified to host some mediation with some of these young people? And also the parents, because it's actually the parents that are more upset about what's happening to the young person. And I'm finding the schools aren't really wanting to take that responsibility for the mediation. So then either the parents themselves go to the court to apply for an RVO, PSRVO, personal safety intervention order, or they come to their local police station to seek advice. Sometimes it's not advice. They're at that point, they're irate and they're like, something needs to be done about this other young person. They're assaulting my child. This is not on, something needs to be done. So In our team at Wyndham, we have a youth tasking unit that's specifically linked to all of the schools in our areas. So anything of wind of this, there are members downstairs that are a reception know to come up to us and say, we've got a family in, this is what's going on, can you have a discussion with them? So then we then go, yeah, we'll take all your notes, we'll contact the school and do that follow-up. That usually leads to us contacting the other parents, contacting the school, and very rarely turns into personal safety intervention order, because we also have every afternoon the embedded youth outreach project team. So every afternoon from 3 p.m. to 11 p.m. we work with a YSAS youth worker, and that young or that family and that young person that's a victim of this bullying has the opportunity to speak to a youth worker. If the family still want to pursue or explore intervention orders, there's a liaison officer at the Melbourne Children's Court that I say, please speak to her first, and I give her details, and she will talk to them about what an intervention order is. And if she then thinks, yeah, actually, I think your young person does need this order, this does sound really full on, and it does sound like it's getting too much, the conflict's too difficult to manage in the community. So she will actually help the family apply for the RBO. So specifically Wyndham, we are really, really trying our best to divert young people out of the justice system. We'll try as much as we can to do that.
Aly and Negs, this is a question to both of you at the same time. Have your services seen an increase in the use of PSIOs as well? What are the patterns that you're seeing and why? And are there any different considerations in the legal response? And I want to ask you, is there any value in the imposition of a legal response in these contexts? Are there times when this response is necessary or useful, or should we discard this as our standard response when a young person is identified as using harm?
I'll try and keep it short. If we think about our justice system more broadly, it's a colonial one. It's obviously created abhorrent harm to our Aboriginal and Torres Strait Islanders, and similarly to most marginalised and oppressed groups within Australia. And it's been modernised, and we've made changes and whatnot, but it's still got those origins. And I think we've heard all day the nuances that go into AVIF and the background, and I just think it's foolish, really, for any of us in the legal system to think that it's going to adequately address these issues, and that myself or police or magistrates are ever going to be the people best placed to address this issue. Intervention orders are ideally there to keep people safe, but they just don't always do that. They do often put people at more risk. In the context of schools, for example, it's very hard to control what's said around a school. Even if there is an order in place to try and keep another student safe, word usually gets out, and it really does put that young person often at increased risk of bullying, and ending up not going to school, let alone putting the respondent young person at risk of breaching that order because they might not be given appropriate support from the school to help them follow it. So they're trying to do what they think is right and going to class and showing up, but the school hasn't actually separated them out into different classes. So the intervention order itself is just not enough and doesn't really do the job. And if we think about, I understand that other people in the home and victims and siblings and they have a right to feel safe, absolutely, but I just do not think that intervention orders actually do that. And I think that there's no way that they ever could, really. That's my short answer. I could go on a lot longer, but that's the condensed version, I think.
Look, I think in practice right now, what we see is a knee-jerk response to, particularly when we're talking about PSI VOs. There isn't this, in-depth conversation that occurs with families. There's no mediation. There's no really deep diving into what the issues are. The knee-jerk response, it is a couple of days after the incident that the PSI VO comes to light. So there really has, as it stands, there is no, there's really not enough of a therapeutic response or approach before we go ahead with the intervention orders. And I think probably agree with Aly in that it just falls short of what is needed for young people. And what we do see, particularly in the regions, in regional Victoria, is young people being essentially, it's so difficult to comply with those intervention orders in the schools that kids stop going to school. There are definitely instances before lawyers get involved, before VALS gets involved, where those intervention orders exclude the young person from school entirely. So I don't see how the current approach really is fit for purpose. I mean, it really goes to the title of this whole session around, one size does not fit all, and certainly the current status quo is not fit for purpose for anyone. So I think it really requires us to sort of take a step back from these knee-jerk responses and going through the system, whether it's PSIVO, whether it's a family violence intervention order, and really looking at the young person in a holistic sense as best as possible, and bringing parties to the table to really get into the nitty-gritty of what the issues are. It is so harmful to introduce young people into the court space, civil or not. And yeah, I can't see how it would benefit anyone.
Fantastic. Thanks, everyone. A final question to the whole of the panel. What do we need to see in order to make change? Is it about changing the legal framework, changing culture of how or when to use these types of orders, or is it something else? What's the one thing that you would do to improve the situation for young people?
I think there needs to be more investment in the therapeutic supports rather than the after. And so if it is a situation where we're able to intervene at an earlier stage before the bullying gets out of hand, I'm certainly not sitting here saying that young people should have to put up with bullying, but what I'm saying is that an intervention order or the court process is not the way to manage this new generation of young people that come forward with social media. That investment in being able to tailor specific supports to young people, whether it's in a group setting, whether it's one-on-one, is, I think, the investment that's really needed. And specifically when we're talking about Aboriginal young people, like I mentioned earlier, a very, specialised family violence program or a family violence worker, whether that's, again, in a school setting or at home, I think investment needs to be made to ensure that young people are receiving the therapeutic wraparound and culturally safe supports that they deserve to give them hope for the future. I think we're in a very different time right now where you make one mistake and it seems to be that the young people are under the magnifying glass for a long period of time. You can't make mistakes like you used to. I mean, I'm not that old, but I remember kids used to get in fights all the time at school, and we certainly didn't drag them through the court system for 6 months. So I think we probably need to take a step back and see where are we failing? And at this point, we're failing to the point where we're dragging kids through a system that is only going to see them progress into the criminal legal system, and that's not what we want for anyone, let alone our kids.
In terms of small fixes, not having young people told that not to go to court if an order's already been applied for against them. Sure, idealistically, they don't have to come to court, but that's just really disadvantaging them at this point. If it's been applied for, they should come to court. They should get the opportunity to have legal advice. And the other supports that do become available to them through that process, I think that's the wrong point for them to be able to become, available or really explored. But at the moment, that's the system that we've got. I mean, there's obviously so much more policy work and things that can be done, and we are at that stuff takes time, and we're at the mercy of the government of the day. So that's really tricky. But I think for all of what Neg said, the therapeutic approach really needs to be explored before any intervention order. I think there should be a positive obligation on people who are applying to really demonstrate that safety plans have been in place. They haven't worked for this reason. They've been revised. What supports have been in place? If they're an Aboriginal and Torres Strait Islander family, have the local ACCO been out, or is there another culturally appropriate organisation that can come out? Are they disenfranchised from school? Can they get involved in school? Like all these other protective factors, have they been explored? Have they been addressed? Mental health. And if we really are at a last resort of needing an intervention order, then okay, we may have to look at that. But the moment that none of that comes to light, that's what us lawyers have to sort of dig through when we're trying to advocate for these young people, and it's the wrong way around. So I think that obligation should be on the applicant before they can even put in their application. We're a long way off that, but that's my theory.
I love the idea of a rapid response service from a therapeutic lens. That would be amazing. But in the meantime, just the risk assessment for police, where it's got specific things for young people, would be awesome. Yeah.
Okay, fantastic, everyone. And for what it's worth, I just really think we need to change the law. We need to change the legislation. We need to get in there and recognise that as much as we thought we were doing the right thing, and we were all those many 15 years or more ago when we were trying to expand the definition, we didn't have the understanding that we do now. We didn't understand that there are inadvertent consequences, and that certain cohorts, whether it's First Nations women, as we know, or young people, can essentially get misidentified or get swept up in a response that sort of has zero tolerance or no excuses, and just doesn't have that nuance, doesn't have that capacity to respond to diversity and complexity, and tries, as the title of this session suggested, tries to be one size fits all. So I think we really need an opportunity to revisit our framing, our responses, because we know, as we've heard through the course of the discussion, the wider discussions today, there's so many complex considerations involved in this work. So we have a bizarre tension between the, nuanced and complex and adaptable and really agile responses that are being demonstrated in the practice by all of the people here in this room, and then a very, very blunt legal response that does very, very little to recognise trauma, to recognise language delay, to recognise systems abuse, where parents might be manipulating the system to perpetuate their psychological and emotional control, which unfortunately we saw in that PIPA project as well. And where lawyers like Negs and Aly and police, fantastic police like Grace, are working their hardest to find ways around that, and to bring kind of discernment, and to bring discretion, and to bring compassion to a really, really blunt response. So I hope that this conversation has inspired you to kind of think about things in those particular way, to call for that reform, so that we can get to a point in our legal response to family violence where one size does not actually fit all. Thanks very much for coming.